So several years ago, actually, because just to bring us up to where we are now, for everyone in the audience, we had the opportunity to engage with the principals of Hampshire, really to talk about Hampshire Road and the issues around the traffic and safety. We had a conversation with them about how can we address this, because for those of you who live in this area, those of you who live in the community know where Hammocks is in terms of arrival and the traffic pattern and so on, and just regular traffic, that area is problematic. And so there was an initial conversation about what could we do creatively, what would it look like to go to the town to change that, to improve that. And that's just primarily from the acoustics of these.
Or embarrassment factor. I'm Edie Roth. I live in Mamaroneck, and I wanted to first thank you all very much for what you do. I know it is often a thankless job. One of our greatest assets in this community is our school system, and the fact that Dr. Schaps and all of you work so hard at maintaining its caliber is wonderful. And it is in all of our best interest to maintain the quality of education in Mamaroneck and Larchmont. And I think most of the people here recognize that fact. I think any donation should be considered. I love donations. I think that there is also, in this situation, a lot of fine print associated with the donation that many people in our community probably are not aware of. And I think it's critically important that the school board explain some of those strings that are attached to this donation. We are not simply receiving land. We are potentially receiving a donation that has lots of ifs, ands, or buts associated with it that are probably not deliverable by this school board or maybe by the school board that follows you. And I think that that has not been made very clear to our community. Our community has heard that somebody's willing to make a very large land donation, and then there was no, and here are the things that we need to do. So with that in mind, I think it's great that we're all meeting, because I think one of the critical pieces is for all of you to understand the ... that comes after the donation. And those are, I think, the issues that I'm concerned about. I love our school district, and damn, I wish I could donate land to make a bigger school district too. I'm not sure this is the way to achieve that end goal.
Hi, and unfortunately these are going to be somewhat lengthy remarks, but they're prepared and detailed, and I hope to be helpful. My name is Celia Felsher. I'm a resident of the Village of Mamaroneck. I understand completely what you're addressing, and want to thank you for holding the meeting. As some of you may know, I was in fact on the school board for 6 years, and I was president of the school board for 2 years. We also, during my tenure, faced desperate need for additional fields, and even then faced the pressure of increased enrollment. I therefore understand the issues that you're facing and the obligations of the school board to consider what's best for the district. For full disclosure, I live near the hung school, across from the golf course, and I'm president of the Mamaroneck Coastal Environment Coalition, which has been deeply involved in the issues affecting the development in Hampshire from the very beginning. So while I do have an interest in this, I also have an enormous amount of history and information that may prove helpful, and I'm happy to answer questions at any time. I want to say first, just like Edie did, that I would be wholeheartedly in favor of and support a gift of land by Hampshire to the school district. If a gift were being offered and the board determined acceptance was in the best interest of the district, that would be a win-win. It would be terrific for the district and the community. But this is not a gift, and you are not going to be voting on a gift. As I'm going to show in these remarks, if you approve the agreement, you will be no closer to getting land. You'll be voting on a lobbying agreement where the only binding agreement of either party is for you to help a developer achieve its financial objectives to build a luxury condo development through rezoning, and that's a rezoning that's already been rejected by the community. The agreement itself, by the way, is your lawyer here yet? Well, I will give him this and he can answer. I do have some things for him. The agreement itself is probably illegal under New York law because New York law prohibits any lobbying agreement where compensation, in this case, the gift of land valued in excess of $5,000, quote, is contingent or dependent upon the passage or defeat of any local law, ordinance, regulation, or resolution by any municipality or subdivision thereof. In addition, the district cannot commit to any course of action without undertaking an analysis under secret. Since that review is required at the earliest practicable time, it's very possible that secret review needs to be done before you sign the MOU. This needs to be reviewed with your land use council. As for the substance of the MOU, and I have copies of this, I'll give to you all. As for the substance of the MOU, this is merely an offer of a possible gift at some point in the future with two significant conditions, neither of which will probably be fulfilled. One is that Hampshire is able to get other property rezoned, and this is property you have no interest in, by the village and obtain all required permits and other approvals for the original development plan of the 121-unit multi-story condo complex, including a parking facility for hundreds of cars, on property not currently zoned for that development. And by the way, a matter but for the possible gift, as I said, you would have no interest in, which is why it's a lobbying issue. And second, that after investigation, the school district is satisfied that the property offer can be used for the purpose desired, which is listed in the agreement of building a new school building and developing a playing field and tennis courts. The MOU terminates in 6 months, unless the Board of Trustees agrees to consider rezoning in that time frame. And then, it's like a joke, the MOU is extended only for another 6 months, which Hampshire must receive final government approvals for the project, which would include not only the rezoning, but also all administrative board approvals. Now, if you even tried to get an addition for your home, you know what this is going on. Given that it will take years to obtain all such approvals, the MOU and any agreement to make this conditional gift will terminate long before that condition is met. This underscores that the MOU is not about a donation of land to the district, but merely about enlisting the school district to promote rezoning. In addition, if the final project differs in any way from that original development plan, which it's bound to do, the obligation to make the gift is void. For example, in negotiations with the village boards, Hampshire might reduce the number of units to 100 from 121 to, say, 97. In fact, that's what they did offer at the time of the rezoning back 10 years ago. Or they may find, as is likely, that if several acres are removed from the golf course due to a gift, that it's no longer feasible to have an 18-hole golf course. There would then be no gift. Note that the American Society of Golf Course Architects says that a par 72 course would require between 120 and 200 acres. At 110 acres, with a par 71 course, Hampshire is already on the very, very small side of what can work. And some golf course acreage, if it's in accordance with the original plan, will also be lost in connection with the condos. There isn't even any obligation that Hampshire Recreation continue to own the property. Once the property is rezoned, and as soon as it's rezoned, it will skyrocket in value. Hampshire could sell the property and the development rights to another developer. And you're stuck. You've got no recourse against anybody but a shell. In addition, the things it appears you're getting, you already have. First, Hampshire is always free to make the specified gift to you. They can do it today, they can do it tomorrow, they can do it if there's rezoning. No one needs an MOU for that. And there's already sufficient information publicly available to do much of the investigatory work to determine if the specified land is suitable. Finally, the agreement, and this is something that's, the misinformation is astounding. The agreement will have no impact at all on the ability or inability of the developers to move forward with the housing project. The planning board denied the housing development application for many justifiable reasons articulated in the findings from the EIS, including flooding and other health and safety issues, many of which, by the way, would be applicable in the condo development as well. Hampshire sued the village demanding the planning board decision be overturned and the housing plan approved. The judge rejected these claims and denied the requested relief. All the judge did was remand the case to the planning board to study certain issues more thoroughly. Even that portion of the opinion is being appealed by the village. And I have copies of the opinions here, which I'm welcome to share with you. As I know, I'm sure you're aware, Hampshire's objective from day one has been to build a condo complex, which, based on their own filings, would lead to a net profit of about $55 million. However, based on the current zoning laws, the clubhouse property is zoned, and this is important, marine recreation. It's illegal for Hampshire to build any multifamily units, much less a 121-unit luxury condo complex. Hampshire has, over the years, launched many public relations campaigns, often with incomplete or misleading information, and using scare tactics to try to convince the community to support the rezoning and put pressure on the village board to entertain the rezoning petition. This was carefully reviewed 10 years ago, and in early 2014, the Board of Trustees declined to consider rezoning due to a range of issues, including health and safety risks to first responders and residents in the event of flooding, added traffic in small, congested, and in some cases private roads in the vicinity, and the risk that this would lead to rezoning and high-rise development of the other marine areas, including the boatyards and other recreation clubs around the Mamaroneck Harbor, changing the character of the community and putting pressure on municipal services, including schools. Hampshire sued the village then over the decision, both in state and federal court, and they lost both cases. Again, I have the decisions with me. Once the zoning was denied, Hampshire proposed placing a 105-home housing development on the club property, in large part again to pressure the community to support the condo plan. As noted earlier, the application for the housing development was rejected, and the village is confident that its decision will be upheld. Given the rejection of the housing development, Hampshire has decided to try yet again, this time using the school board, to achieve its desired outcome with condo complex development. If the MOU is signed, Hampshire will, and by the way, it began even before you guys made public this whole thing, to engage in a PR campaign to use the MOU and the school board support to pressure the village and community to support rezoning. If the board approves the MOU, it will be acting as a pawn of the developers and getting almost nothing in return. It also will get the board involved in actions that, at least when I was on the board, would be viewed as inappropriate. As noted earlier, this MOU is not providing a gift. The referenced property would only be gifted if several significant conditions are met, which are unlikely to be met, and only if the district follows through on various obligations, all in a time frame that will be impossible to meet. Basically, the school is being paid, Hampshire will possibly give you desperately needed land, if you assist a private for-profit real estate developer achieve its unrelated financial and development objectives. Is it appropriate or even legal for the school board to engage in lobbying another municipal board for a zoning change that the community in the past opposed, and the sole purpose of which is to enrich a developer? This quid pro quo, by the way, is made perfectly clear in the MOU. The school district explicitly agrees to support Hampshire in its attempt to rezone the clubhouse property. In fact, the district agrees, quote, to share the attached materials and other information with the school community, i.e. to assist Hampshire with its PR campaign and itself put pressure on the village board of trustees. The district also agrees to interact and engage with Hampshire with respect to its pursuit of zoning, including by giving Hampshire written notice of any intended meetings or any communications, oral or written, with any government regulatory agencies having jurisdiction or input, quote, so as to give Hampshire the opportunity to attend or participate in such meetings or communications. I mean, really? Is that something that the board can legally do? What if the district is asked, I'm a lawyer also, we would never agree to something like that in a contract in a million years. What if the district is asked to provide information to a government agency, a court, an enforcement authority, and disclosure of the developer is prohibited or not in the interest of the district? Tough, you can't do it. The village board of trustees already rejected the request to consider rezoning, and as indicated in the letter sent by the current mayor, is not inclined to consider it now. The efforts to rezone were widely opposed by the community. And it wasn't just Orienta. So, you know, that's another piece of this puzzle. So, oh, it's the rich guys in Oriental, this is a NIMBY thing. The efforts to rezone were widely opposed. Why would or should the school district get involved with trying to pressure the village into undertaking this action? In addition to being well beyond the school district's expertise, this would be divisive and have the school board embroiled in a matter that could pit one part of the community against another. It could also erode support for the district, especially among a community that historically has been very supportive of the district and school budgets. Given that the benefits of this MOU are illusory, the school board should be asking if this is really worth it. While it appears that the MOU gives the district a benefit by allowing it to investigate the property prior to acceptance, much of the information needed is available in the very thorough and detailed environmental impact statement prepared for the housing development. The information includes detailed topographical maps, flood simulations, and information on soil contamination and ground soil conditions.
There's so many people here. I just want to be respectful that everyone get a chance to talk.
Okay, do people remind if I finish? It's about 5 more minutes. Thank you. The district can therefore, either directly or through expert consultants, do a significant amount of due diligence that it would need to do without signing the MOU. Note that the MOU does not permit the district to take soil borings without special permission, which should not be acceptable to the district, since if you accept the land, you have to accept it, quote, as is, close quote. Those soil borings would be critical in determining whether the property is suitable for your desired purposes, including understanding the possible contamination with arsenic and other toxins, and whether the location would support the types of structure desired, even given that much of the club property consists of landfill, and that large amounts of clean fill will be required to bring the property up to required flood elevations. Even if you could determine that you could re-engineer the site and achieve safe egress through changed roads exiting at Hummock School, you would need also determine how can you protect the school district's property from damage and destruction in flood events. The entire club property is one huge basin. Floodwaters enter from several places, as hopefully everyone in this community knows. They enter from the area by the sluice and culvert, that's very near the Hummock School. They enter from Eagle Nose Road up toward the clubhouse, from Cove Road and Hummocks Road, and through Orientas. Flood and water management have to be handled as one comprehensive plan. Before determining if the property is suitable, you would have to determine who would own the rest of the property. After the plan is completed, there'll be a condominium corporation, there'll be a club and clubhouse, and of course the district, and there may be other parties. Are the other parties financially sound who will put the effort and money in to ensure that flood protection over time? You would need, and I'm sorry, it seems like I'm boring some of you, but that's okay. You would need to have drafts of those agreements in place and understood before accepting the property. Also, the drawing, which just came out today, seems to show the new field, 2 new tennis courts, and a couple of new buildings. How will those buildings be funded? The cost will be significant, especially given the nature of the property involved. Will the school board propose a bond for the community to vote on? Will you rely on private fundraising for the cost to build and maintain, including the water management of the field and tennis court? Do you have estimates of the total cost to the district? Should you sign the MOU or even accept the gift without knowing what the estimated costs would be and whether you can obtain the funding? Please consider, therefore, that it's quite possible that after review, the district will determine the property is not suitable. Yet, that is completely irrelevant to the developers who already would have used you to do their bidding in trying to get the clubhouse property rezoned. Please consider also that given the obligations to support and assist the developers to achieve their desired rezoning, the board will sacrifice its independence in addressing issues raised by the rezoning and planned condo development over time. For example, if it turns out that aspects of the plan that adversely impact the Hummock School or create other concerns for the district, you are, in this MOU, prevented from doing anything other than supporting the developer's efforts, even if they would be detrimental to the district. That's the epitome of the type of irrational decision-making that could place the district at legal risk. Should you, are you even legally permitted to contract away the school board's right to independently take a position that's in the best interest of the district? In closing, I urge the board not to sign the proposed MOU. Investigate the property fully and openly with publicly available information. And I beg you to be open and transparent with the community as the process and thinking develops. Thank you.
Forgive me, my notes aren't nearly as well prepared. But my name is Charles Mannis. I'm a resident in Larchmont. For one, what I heard is for due respect, a lot of fighting, a little bit of fear, but fundamentally I think we've lost the track on the ball. What's the value proposition? And I don't understand why it's considered a bad idea to accept. It may not be a completely free gift. It may be a quid pro quo, but why is that a bad thing? Fundamentally, at the end of the day, the school district would receive not only acres of land it desperately needs, but a pile of tax revenue it could use with very few extra kids added to the school district. So, I mean, that's the one question I asked earlier, how would you fund it? Well, presumably the millions of dollars in additional tax revenue you suddenly receive from these condo complexes. Whether the lawsuit wins or not is fundamentally, I don't think, people can take different opinions on that. I don't think it's a problem as a school to want to expand and add green space that it desperately needs. Whether this will get done in 6 to 12 months, I don't know, but presumably another iteration of the MOU could be executed. So I don't think it's fair to characterize this as a mere pawn. Ultimately, the high-level question is, does this benefit us? And fundamentally, as someone who's putting 4 children through this school system, I would dramatically say, absolutely yes, it does, and why we would be crazy not to consider it. Are there things that need to be adapted? Can the land be dealt with? Yes, those are all manageable risks that you deal with then and there. Let's get to the actual part where we have it. And fundamentally, that's pretty much it.
Good evening. I'm Tom Murphy. I'm the mayor of the Village of Mamaroneck. Thank you for having this meeting tonight and for giving us the opportunity to address you. I understand the pressures that you're under as elected officials. I understand the competing needs, the competing constituencies that you have to do. And I know how difficult that is. And I know that the school board is probably the hardest elected job in this community. You get no pay, you get no honorariums, and you have the most difficult decisions because all your decisions have to do with the welfare of children. It's, you don't have to, you don't get calls about somebody missed their garbage pickup. You get called about, somebody's child really needs help. And I respect what you do. And I've seen it up close and personal. But, a lot of folks are going to talk about Hampshire today, and I understand that. But I want to give you another perspective. I'm the mayor of the whole Village of Mamaroneck. The Village of Mamaroneck has a marine recreation zone, and it has a marine zone. And these are essential elements to what make the Village of Mamaroneck the Village of Mamaroneck. They have kept our waterfront active, and we have real boatyards that have been lost to many, many other communities. We have country clubs that are thriving and that provide quasi-public access to thousands of people a year. This is what makes Mamaroneck Mamaroneck. It's not, for me, about rezoning Hampshire, although I'm against rezoning Hampshire. It's about what this will do to the whole marine recreation zone and marine commercial zone. It'll change the character of our community. We've been approached by different developers over years wanting to rezone commercial and recreational areas of our community. And we've really stood fast and oppose that because it's so vital to Mamaroneck. You know, because Mamaroneck is so diverse, it has a variety of people who use that harbor. From the folks who have a 15-foot boat, and that's their vacation for the whole year. They don't go anywhere. They go out and they go fishing. And folks that have expensive yachts and directors, which caters to, you know, upscale yachting. And we're very proud of that, and we want to maintain that. Now, everything that Ms. Belcher said about the state of the lawsuits, I believe is true. I believe that that comports with what I've been told and with what I've experienced and watched. We feel confident in our legal representation. We feel confident in our case. So you're asking another elected board to take an action that they've already denied, that they've already went to court and won at great expense, that denial. And it's not a board that is going to take the responsibility of protecting a community like my board. And I understand the need for fields. We have the need for fields in the village of Mamaroneck too. We're all one community here. But we have to look at the larger picture. I have to look at the larger picture. And I can tell you unequivocally, the village of Mamaroneck board has no interest in doing this. And for you to lobby us, it puts us all in a precarious situation. It might put us in a situation with a legal adversary someday. And for what? You know, a pie in the sky? It's not worth it to me. And you know, you make your decision as best you can. But I know my board, and I know that's where we stand. So I hope that takes you know, a large precedent for you. And I've offered to meet with any one of you who would like to meet, or the administration. I find it disconcerting to have no discussions with the village of Mamaroneck when you want the village of Mamaroneck to take a decision that's, you know, been validated in court and change it. You know, we spent hundreds of thousands of dollars to win that case. So I caution you to tread carefully. If someone is telling you that it has to be done right now, that's always the giveaway. That it's not a good thing. But walk away, think about it for a while. Have discussions, get another point of view. Thank you very much for your service.
Evening, folks. My name is Jack Lusk, and I live at Cove Road. I really appreciate the fact that you're provided us the back and forth opportunity. And in context, I'm following Tom because I don't understand how come you didn't talk to the village or the town or any of the other bodies that regulate the community, and we end up in this discussion. So there must be a history here where you ended up negotiating an actual deal with a developer. But I don't understand how it got started, like why it wouldn't be a public discussion. Pretty much what Celia said, and I think what Tom's saying is, we would all work with you to try to figure this out. I've looked at your map and it's pretty obvious that there's some possibilities there, but I don't understand why this wouldn't have been a public discussion in the first place.
So I don't think you were here at the beginning when I gave a sense of how we arrived.
Yeah, you said you talked to your principals. That's the exact thing you said you met with your principal.
Please let me just clarify, because when the group was here at 6 o'clock, I talked about how we arrived at this point, and I'll repeat it for the full audience. It was several years ago.
I can't hear you. Microphone?
So several years ago, we had the opportunity, to have a discussion with Hampshire about Hampshire Road. That how do we address the safety issues and the possibility of addressing what is problematic historically with the buildup of traffic, school, and the flow of traffic. And so there was an initial informal conversation about what would alternate road look like, which then led to, in terms of thinking about the design, the possibility of adding to the footprint of the school, which led us to an informal conversation, and I'm talking about the administration, with a discussion of what would more land look like to expand our middle school because of, as was described in the opening page of a draft MOU, the conditions that we face as a system. And so that's really a conversation. As I said earlier, from the school system's perspective, it is about land. It is about considering the potential for a gift and all the, what I say, follow through that is required to consider. And so it is in this agreement, this discovery phase of saying if down the road, okay, and this agreement does have the opportunity for extending this MOU down the road, things get resolved in any direction, there is a potential to receive a gift for land. And that is under the purview and responsibility of the school district to think about that prospect.
I totally
So
understand.
that is the extent of it. I want to give a parallel example because I think it's important. Tom Murphy talked about the interest to collaborate and come up with long-term solutions. I would say historically there has been continuing meetings and discussions within our government agencies and school district to talk about development, to talk about the plans of each municipality, so we have informal conversations. That has been my experience for 14 years as superintendent, and I would say that historically, when the village of Larchmont, the town of Mamaroneck, or the village of Mamaroneck previously talked about something in their plan, there's been preliminary conversations that allowed for collaboration around impact. Okay? Our interest, at least from my perspective, in looking at this MOU and potential agreement is to continue that conversation. So, this is not a if or and or but. This is a start of a process. And so you can agree with that or not, but simply, as I said at the beginning, this is about the prospect of a future potential gift.
Right, but you put in your MOU that the school board has determined it's in your best interest for that property to be rezoned. You made it, you say you determined that. And so I'm just asking, did you talk to the town about what it would do for them? Did you talk to the village what it would do for them? Did you talk to anybody about the fact that the lawsuits besides the people you're negotiating with?
And I would say, I want to give people the opportunity.
Sure.
I appreciate the question. I think the next logical step, whether we can agree about the order of things, is the conversations that we'll have all the above. Certainly we know through Exhibit A that was presented publicly that any conversation about changing Palmer's Road in order to allow for development would have to be a discussion with the town. So there are a lot of things that need to be explored, but simply put, this is about potential gift of that certainly could come about in the future if certain conditions were met from something that we're not involved in or in control of. So that's your comments. I would ask that we have Tom Spethler here, and I think as he is our legal counsel, and I think as he did last week, describe what this draft agreement contains. I think I want to give the opportunity for at least Tom, because there was a question, there was at least a discussion about what are we obligated to through this draft MOU. And I think it'd be interesting for him to at least give his perspective.
Sure.
Thank you, everybody. I apologize for being late. I missed some of your comments. Can everybody hear me? Again, the MOU is specifically designed to provide factual information. We're not becoming a public relations agent for Hampshire. The agreement requires the district to provide factual information about the impact of the different proposals on the school district. The school district is charged with determining what is in the best interest of the school district. Not what's in the best interest of the village, not what's in the best interest of the town. Evaluating the issue from the perspective of the school district. That's what these people up here have been charged with doing. And that's what they are considering in the MOU. Is it the best interest of the school district? And again, from my perspective, it is not becoming public relations. It's not advocating It is providing factual information, it is providing the demographic studies, and eventually, we haven't gotten there yet, but it would be providing the different options and what the costs would be.
My comments are pretty quick. Hi, Julia Steinmetz, longtime local resident, 20 years, Village of Larchmont, 2 years, Village of Mamaroneck. My property happens to have an easement on the private road of Hampshire Club, so I couldn't get much closer. I would just like to point out a couple of things. First of all, I don't consider this actually a gift because there are so many strings attached. If the developer would like to actually gift the property, let them do it free and clear with no strings attached, not contingent upon whether they get their $55 million profit, which is how it is now structured. Second, I think that it is improper for the school board to be putting itself in a position where when they ask what is best for us, that it pits one part of the community against another. If you just want to consider it, in a vacuum, what's best for us? Well, mow down some of the condos and put some fields up. But that's not the world we live in. And this is in the community that has already decided against it, not once, but twice. And my final point is, everyone has been talking about the flooding. It's not just a flood zone, it's a bathtub. And I've walked my dog there every single day for the last 2 years, and every time it rains more than an inch, or we have some onshore flooding, the water comes up over the berms and it stays there. There is a reason why this land should not be rezoned, and that the developer bought it with the plan of forcing the village's hand to rezone it was also improper. They tried to make some case about takings, but that's not how takings work. So I would really encourage the board to consider their political position and also consider that this property is just not suitable. Thank you.
Hi, I'm Melissa Manis, resident of Martha. Sorry. In the audience, can you raise your hand if you live in or around Hampshire Golf Course or Hummocks? I appreciate the commitment of the residents that sit around Hampshire, but I also would like to say that I also appreciate that the school board is willing to consider a broader benefit. And what I'd like to ask, because I think it was brought up by Mayor Murphy with regards to the school district collaborating with the community, is that if we look at the legislative discretion to look at rezoning, for example, Mayor Murphy has recently looked at the Hunter parking lot and rezoning that from commercial property to residential to allow for 50 families to enter the district. I personally, as a parent in this district, think that that is something that the school district should be intimately involved in that decision because it does have direct impact. But what I've also looked at is the recent decision from the judge in Westchester County surrounding this case, and that the court has ordered discovery and furthering of the lawsuit of the takings claim of the Hampshire Golf Course. And I understand that the focus here tonight should be around the terms of the MOU and the accepting of the gift. But what I would ask the community to consider is that if we think about option C, is that the developer will just go away. And that's what we're hoping if we maybe live on Coles Road or Thomas Road, and I can completely understand that perspective. I think we also need to consider that option A, which is 106 single-family homes impacting our school district, is really possible. And so I'd like to ask the school board to consider, and so when I think about option B of 55 plus housing that preserves an 18-hole golf course and allows for 10 plus acres and a greenway connecting our community, to me that is compelling over 106 single-family homes that again completely decimate a golf course and that entire set 103 acres of green space. Thank you so much for your time.
Hi, my name is Nicole Fissel. I have 3 kids, one at Central and 2 at Onyx. I've been very involved in both schools as well as at the district level. My husband's been on the enrollment task force. So we've been very involved with the district for many years. I guess having kids in the district right now, I have huge concerns about space. My 2 kids at Onyx talk about the lunchroom and how literally the entire grade cannot sit in the lunchroom right now in 6th grade because there is no space. They are not allowed to wear backpacks in the hallways because they are literally afraid of injuries because there is no space going up and down the stairs in between classes. Additionally, I don't know that everyone's aware that the fields behind Onyx are not owned by the school district, and we do not necessarily have say in or control of when we can and cannot use them, which is really limiting for the Onyx kids. All 3 of my kids are also involved in sports in the district, and field issues have been tremendous. Also, in terms of enrollment, my daughter is in the 4th grade at Central, and for whatever reason, that year is very, very small across the district. They literally saved the district from the enrollment issue when we were talking about rezoning. That grade came in and was so small that it saved the district from drastic measures, essentially. So I guess what I would like to say is we're in a desperate situation and we really need space. And I do think it is really important for the district, for the Board of Education, to look at this and say, even if it is a 1 in a million shot that we get this, we need to look at it and we need to seriously consider it because, frankly, we're desperate for their space and we're not like other areas in Westchester where maybe there's space that isn't being used right now. Every inch of space in all 3 of our municipalities are being used. There is not another option for us to expand our schools. I mean, if you look at Chatsworth, you look at Central, you look at high school, we are surrounded, it's not urban, but we are surrounded and we don't have extra space. And I very much respect everyone who lives around the development and the village of American government. And at the end of the day, I guess what I would like to say is that I understand this is not your decision, and you may be signing this, and it's a 1 in a million shot, and it may never happen, and I respect that. That's the Village of Amerenic's decision to make. But I think in the interest of the school district and the interest of our kids, it would be going against what you guys are supposed to be doing to see land come up and not take a chance on it, and maybe it won't happen. And my kids definitely won't see it at this point. But I think it would be irresponsible of the board to not take a serious look at it, to say even if it's a 1 in a million shot, we want it. And then let the Village of America do whatever it is that they decide is proper on their part. Thank you.
Thank you.
Hi, I'm Andrew Kerwin. I live in the Oriental section of the town in the Village of America. I am a board member of the Oriental Point Association. How about now? Is that better? Anyway, I'm a board member of the Oriental Point Association. It's a neighborhood association that includes the Hampshire golf course. And I've been asked to raise 4 points with you. The first point is, I'll just read it. The issue has been brought to our attention with no warning. The school board should not be spending time and money to investigate whether fields can be built and sustained on land that may be gifted. Emphasis on the word may. The second item is the school should not do anything until such time as Hampshire is ready to make an unconditional gift. Third, once and if Hampshire is offering an unconditional gift, then the school should do a feasibility study. 4, generally, we believe the school should not intervene in local zoning and housing development issues, especially one that has been litigated, has been before the boards of the Village of Amerenik. The school should just wait on the sidelines until such time as there is a final outcome with the village. That is what I was asked to speak on behalf of the Oriental Point Association. Now I'll speak as myself. I have coached Little League for 11 years. I've watched my daughter play field hockey. I've watched my son play baseball through high school. And yes, field is a big problem. But I can tell you this is not the solution. This spot is not a field. I was there at the environmental assessment meetings at the village. I heard Dr. Schatz talk about the impact of this extremely large development proposal and the impact on more numbers of schools. Prior speakers spoke about crowded hallways. Well, we may get more crowded hallways with the development of the size that this group has been trying to put before this community for a long time. There are other ways. When I read the environmental impact assessment and I read about all of the landfill that would have to come in, how in this area, believe me, if they're giving you, they're giving you this gift, I've read, and it's going to require a ton of environmental work just to make it possibly feasible. And why should the school be spending any time or money? You have an attorney here. I suspect that they charge for their time to do research and things like that. And it's not worth spending any school money right now until such time this developer says, you know what, we're ready to give you a gift. When that happens, put all your efforts in it, and if we can make it happen, great, but that should only come after there's been some final determination with the village on whether or not they can develop this land. But getting involved in intervening in an issue that's already been decided by our village board is wrong. And frankly, I wonder if it's ethical for the school board to be even looking into this matter when it's kind of a quid pro quo. Hey, if you get on board with us, we're going to have some leverage with the village. And I think that's a terrible position for the school board to be in.
Hi, I'm Holly Shackner-Wolfson. I've been a community member for about 22 years, have had 2 children go through the school quite successfully, so thank you to all the current and the past school board members, and to Dr. Schatz, congratulations on retirement. I live squarely in the village of Larchmont, so I have no immediate I'd say bias per se, and I don't want to say bias. But I do know that fields have been a large challenge, but I also know that the only thing that's not going to work is for us to pit our community against our school, our towns, our villages against our school. That is one community. So for any decision by the school board to be made without sitting down with the villages and the towns is completely irrational to me. And at the same time, for any of our towns or villages to approve building and development without sitting down with the school board is also irrational to me and has likely gotten us to a point where we are tight. So I understand that. But there should never be a quid pro quo. If there is a gift and we need to look at it, let's explore. That's part of living in the village and the towns of Larchmont and Mamaroneck. We need to be innovative with our space. We need to be creative, but we also need to work with our neighbors and the rest of our community. So that would be my urge. I came here to support, like, oh my gosh, we need fields. The reality is, oh my gosh, if there are strings attached, that is never a gift. And if there are things that we can't use it, that's not okay. So I'm going to ask that everybody work together and work through it. And I would also, it blows my mind, to be perfectly honest, that our schools don't have access to the parks and the fields at Flint Park and at Homage. Let's perhaps solve that. That's what we've been working on for like 20 years since I wrote my first check to Fields for Kids. So let's address that. I think that we can do that first before allowing an outside developer who's sort of looking at $55 million.
Hi, my name is Melissa Campo, and I'm relatively new here. We moved in 2019. Apparently, we weren't prescient and realized there was going to be a pandemic for the city. But I've spent my career as a real estate developer, and I now live on Cooper. So I want to share a few things with you that I think the board should be aware of. The first is, developers, and I was one, so I can say this, notoriously sneaky, guys. There's a reason people don't like developers. There's reasons there are TV shows about bad developers. They figure out ways to get entitlements done. I did it for a decade, really big projects in New York. Happy to tell you stories with schools and all the rest of it. We're getting it around here. And I want to go with eyes wide open. I actually think that accepting this MOU puts us in a compromised situation from a liability perspective. Here's why. The developer's only asking us to sign an MOU, and I say us because we are one community here, guys. We have to remember that we're one community. They're asking us to sign an MOU because they think it will sway the outcome of a rezoning. If they didn't need it to sway the outcome of a rezoning, then they wouldn't be asking for it. Think about it. So we sway the outcome. We may or may not get the gift. The gift may or may not actually be feasible to build. It may or may not be contaminated. It may or may not be in a floodplain. It probably isn't both of those things. Probably doesn't get built, but maybe it does. And then there's flooding. We now impacted the results of a rezoning. We now have our fields, and now we're liable to that flooding. That's a really, really risky decision to put this district in. And we should go with eyes wide open before we even contemplate putting ourselves in that position. The next thing I would say is there are other viable options here from a field perspective. I just wrote a check this weekend because we just moved here for fields for kids. I have 2 kids who play travel soccer, one well, one not so well. And 1 kid who played rec soccer very badly. Sorry, that's my daughter, by the way. She's in the audience. She's writing articles for the Globe. She played terribly. Terribly, terribly, terribly. She's really, really good in the theater, though. And now I'm mortifying her. I say this, guys, because we need to think about what this guy's asking us for and why. It's a contingent gift. Let's go back to him and say, you know what, we love your idea. If you ever prevail on rezoning, we really accept your gift. Because otherwise, we put ourselves in the influence of rezoning, and we, in fact, become the lobbyists. And if the lobbyists prevail, and then there are negative impacts from those consequences, we are potentially liable. And I don't want to go there, and I don't think anyone else here does either.
I'm sorry, I hate to get up again, and I really don't want to be here tonight. But I do have to comment upon a false relevance of changing zoning for affordable housing and changing zoning for 120 very affluent condominiums. To me, those are apples and oranges, and it's not a discussion that should enter into here. But that being said, since I last spoke, Mr. Scapoli has come into the room. And hi Tom, how you doing?
Hey, good Tom.
We know each other from past life.
We do.
A good life.
Yes.
I mentioned before that the Village of Mamaroneck Board of Trustees has no inclination to pursue a zoning change. So I just want that on the record with you, so it's a part of consideration. But you talked about the board being able to educate and advocate, not educate for the zoning change?
No.
Let me just finish.
What I stated is that the MOU requires the board to provide factual information regarding the proposals. If there's a proposal in front of you, we have to provide factual information. I would suggest that it is the district's legal obligation to provide factual information regarding the impact of any application that is before you. And I think as discussed here, I think it is your obligation to consider the impact on the school district in making any decision before the planning board or the zoning board. I think it's just that simple.
I agree with you.
And I think that certainly, I don't know if anyone is suggesting that the district should not provide factual information to the community about that. I would think that you would want the board to provide factual information, and it's something that you'd want to consider, and that's it. It doesn't force the village to do anything. It doesn't, we can enter this MOU, and it doesn't force the village to go one way or another.
I'm well aware it doesn't force the village, but that really wasn't my question. My question was, can you tell me another instance where a school district provided factual information to try and support a zoning change in any community?
I can't say specifically about a zoning change, but school boards and school representatives appear before zoning boards and planning boards all the time.
But it's a legislative, hold on. It's a legislative, it's a legislative action. And then when they appear before zoning boards and planning boards, that's part of the planning process. That's part of the land use process. That's when it is proper for a school board to get involved in that individual project. I'm just saying, I'm not sure it's proper for a school board to get involved in a legislative decision by an elected board of trustees.
Yeah, and Tom, I'm not disagreeing with you at all. I think the law is very clear that you don't have to consider any legislative rezoning issues. You don't. And if that issue is not in front of you, then there's nothing for the district to present information on. It is only when there is an application before you that the district has an obligation.
So let me,
Hold on one second. Is it when we accept the application?
I think it's when you're considering the application.
So we have to first make a decision to consider the application.
let me ask you a question as a lawyer. This is an agreement. What do you think that Hampshire thinks that it's getting by you signing the agreement if it's nothing other than you would have done anyway? And I'll say two things. They, just like Melissa was saying, are basically pulling the wool over your eyes and taking you for a ride. All they want is this MOU signed to be able to go out and conduct a big PR campaign. You know that, and they know that. There's no joke. If that wasn't the case, there wouldn't be anything to sign, because the only thing they're getting from you in return for this cockamamie gift that doesn't exist is the agreement to, i.e., distribute information, i.e., help them with their campaign. And in addition, and this is the astounding part, you agree to engage and work with them and give them notice of any communication, oral or written, anytime you are going to go before a regulatory board or agency. You can't even act for yourself. You can't go to the bathroom by yourself. You're in bed with them. Why would you ever agree to that? They want that agreement because they're going to tout this thing, and then they're going to leave you in the dust because nothing's going to happen in a year. And yeah, who said it can be extended? Guys, if it can be extended by mutual agreement, anything could be. They could give you the gift now if they want to agree it. Put in the agreement now. It's got to last for 7 to 10 years. That's probably the time frame involved. You need to think about what you're doing and what you're giving up. There's no reason to sign this agreement from their perspective other than to get you in bed with them for, by the way, an action that is not relevant to the land you'd be getting. If it were not for the payment to you of this potential gift, you would have no interest whatsoever in the rezoning of the clubhouse property. It's irrelevant to the district. So you wouldn't be there trying to support the rezoning or not if it weren't for them paying you off with another promise. That's why this is lobbying. And by the way, a payment that's contingent on success of a change in law, even at the municipal level, is illegal even if you registered as a lobbyist. And that's what this is.
Good evening. My name is Michelle Calvi. Thank you for holding this meeting to discuss these issues. I want you to know I'm a mother of 2 kids in the district. Both of them play sports. I'm an attorney by trade. I've read the docket, what's going on with Hampshire and the development. And I live on Cove Road. I'm going to try to tell you some things tonight that I've dealt with as I have this internal struggle of being a mother, a lawyer who understands the legal principles, and a person who clearly is significantly affected with this potential development. So I think you have to think about when you're saying what is in the best interest of the school in these particular circumstances. right? Because we're not just considering, is a gift of land in the best interest of the school? Well, yeah, that sounds great, but this is not just a gift of land. As we've heard, there are strings attached. And so we have to consider in that circumstance, is that really in the best interest of the school and our community as a whole? So again, I'm going to really try to talk about things that I think apply no matter where you live and where you're from. But I do have concerns that the land that they are potentially going to gift, if all the contingencies come through, is actually going to be feasible and viable for what we want to do with it. I joined kind of late into all of the village meetings to understand the complexities of that piece of land. I heard a lot of things in the environmental impact study and about the land that were the very reasons why, or factored into why, the village board declines the development, that there were concerns about the viability of building there, the flooding, the emergency evacuation situations, the toxins. So, you know, before we enter into any kind of agreement of a potential gift, we should look at, does that potential gift really give us what we want at the end of the day, or is it going to end up being a liability? Because there'll probably have to be all this landfill, and I don't even know what would have to be involved, but it's very complex, as I heard, and I don't know that this is really going to, at the end of the day, answer the prayers that we've had. The other thing I want to say is that there have been, you know, concerns with increasing enrollment. Those concerns have been present. They're still present. They were present at the time when the board was considering the condo development to begin with. This potential gift of land is not going to help us really with the growing enrollment. And I think that that's true because when you have then a condo development of 121 units coming in, even though you say they're 55 and over, and I think we all know people are having families later in life. Like, my husband will be 55 in a few years, and we're still going to have 2 kids in the district for another 5 years at least. I think there's also unconventional families where just meeting that requirement of having someone 55 and over doesn't really mean that you're going to lessen the impact on the school district. But in any event, I don't really see how building a field and a tennis court then helps you so you could all eat lunch in the cafeteria at the same time, or so you can wear your backpack in the hallway. I don't really think that that's answering our question or helping our concerns. The other thing I want to give as a caution is that the gift is conditioned on the developer getting exactly what he wants, and there's such a short time frame, which we've heard is not realistic. But it's long enough to try to infiltrate our village and divide us and pit us against one another to try to sway public opinion to try to accomplish something that has already been adjudicated and decided. And at the end of the day, maybe you will have compromised yourselves and gotten involved in something that's really not your fight and pressured the board to do something. And you know, maybe they get 97 condos, they win, and we get no land. So I don't really think that accomplishes what we want to do either. I also want to say that I understand some people feel like, you know, well, condos are preferable to single-family homes. And I get that, I guess, but I don't see this as it's this or it's that. I think there's option 3, which is it's neither. But you're not going to be here to decide whether we're building condos or not, but by offering your support, you kind of are taking that stand if you sign an MOU. But basically, just from my review of all of the documents, they initially tried to go for condos, that was denied, it went to the courts, they did not succeed, that's done. Then they were like, okay, well, we're going to now say we want to build single-family homes because that's going to now scare everybody that, oh, we're going to put a drain on the school system, so they'll want us to go back to the condos because that's really what they want. And also the single-family homes, that was rejected too by the board. That was never agreed upon. What happened was there was an Article 78 proceeding that was brought against the board saying they acted inappropriate, they were arbitrary and capricious, they abused their discretion in denying it. And the only thing that that judge in that decision said, well, we'll remand this for the board to take a harder look at a handful of issues. But it didn't say that the board was wrong or denied their request to overturn this. Yeah.
That's
And-
my experience of 12 days ago.
What?
The court set you up for discovery, you're going to trial in 2 years.
No, that's not on this.
They're asking you two things. I want to respond to your comment about the benefit of this plan. If you look at Exhibit A, and certainly-
Well, it just came out today.
Well, if you look at Exhibit A,
So-
it is a public document. I want to respond to your comment, there's no benefit in considering the possibility of this gift, because if you look at Exhibit A, you'll see that the at least consideration in terms of dealing with the enrollment pressures of the school at all levels is to actually expand the school economics, to allow for the shifting of grades, to create additional space and economy through shared space. So the design concept that we're considering as a starting point is to say, how can we add on to our property to build, up and consistent with the design of Hammocks? How can we rethink the configuration of the school, relieving pressures on the elementary schools where we currently have kids in basements learning below ground, and think strategically about configuration to deal with future enrollment growth. So to suggest that there's no benefit to considering by the Board of Potential Learning is not accurate, and that's understanding. With that said, we need to consider the additional impact of traffic flow and parking. And so if you look at Exhibit A, you see in close proximity of district property as well as town property, the opportunity to address an issue of congestion, of traffic flow, of safety. So there are things that are positive from the consideration of potential gift that may lead to a feasibility of a design, that may lead to alleviating enrollment pressures in the system. And that is purely the logic behind the board's consideration of this MOU. So I think it's important at least push back on this idea that there's no potential.
I don't know, I'm not opposed to a gift. I'm just. Yeah. If I stated something.
We all agree with you that if this happened, it would be great. The design is interesting. That's not it. It's what the village, it's what the school is doing by signing this MOU.
I appreciate it.
If there were potential for buildings, listen, we can't argue with, like I said, I started in the beginning, we can't argue with a gift of land. I'm just calling to, exercise a very particular level of scrutiny with exactly what we're getting into, because all that glitters is in gold. And if they wanted to give it, they could just give it, but they're not. They're doing this with a particular motivation in mind. I just want to say a few other things. Just that legally, I think that the village has pursued this in the courts and has been successful. We've been vindicated, and I think whatever's outstanding will continue to be vindicated in the courts. With regard to the MOU and the position that it puts you in, I also would feel very concerned about legal and ethical issues with the board getting involved with lobbying for something that the Village of Mamaroneck Board has already decided with regards to the zoning, and we've heard that they have no appetite to change that. And I also feel that unless there's going to be a gift outright without any strings attached, it's kind of a distraction for us to be bogged down by that's counterproductive, where we could spend our energies trying to find other solutions. And I would hope we can try to find some other solutions. I don't think that this is the answer that we think is going to be. And I just want to thank you for your time and listening to my remarks.
Since Mayor Murphy took a second turn, I thought I would come back. I'm thinking as an individual now. And I wanted to start with, Dr. Shapchi spoke about, shouldn't we take the time to look into this? I think now is not that time. And the fact that we're here tonight, I think is proof that it shouldn't be that time. There is no reason to look at a gift that may not happen. And to spend money on it, to do your own study right now. I'm curious how many on the board, already read the MOU, how many have actually read the environmental impact studies that were presented to the Village of Mamaroneck? Because if you read that, you would know that portion of the land that they want to give to you is Buckus. And it would cost a fortune of money that the school doesn't have to do anything there. The plans that they have talk about putting floodgates in to keep the Long Island Sound out, and that's just, is the school in a position to take on that type of environmental work? It's ridiculous. And it's only for PR at this stage. And I want to thank our resident soccer mom for putting a thought in my head about developers. Anybody notice that they're in litigation right now? And we just heard that we can't wait for a trial. The trial is going to happen. You're going to sign an agreement. And I bet if things don't go their way, they might come up and say, you know what? Let's try to make a claim against the school because they didn't look into this, Laura. The facts they gave the school board weren't correct. No point in getting involved in that at this point until they say, here's the gift we want to give you, period. Right now they can't give you a gift, so why are we wasting our time on that? I really think, give it now, but there is no gift right now. So everyone's time is being wasted on something that's fantasy.
Hi there. My name is Leslie Clifford. I'm a parent of 4 children in the district. I am very involved with comics on a PTA level, with all the schools on a PTA level. I also have 4 children in children's sports. I'm heavily involved on the boards of some of the athletic teams, and I'm very involved closely with several of the people working in this room to improve the field space for our children. And I recognize that all of us are here as one community. But one thing I want to reiterate is because I am pro this deal, that does not mean that I have the wool pulled over my eyes or that the school district is palmed. It simply means that they are weighing other considerations. And I think the school board would be remiss to not weigh the opportunities presented by this. I do not think that the developers making money on this deal mean that the school board has to walk away from it. I do not think that because there are strings attached to this deal, it does not mean that there could be a positive impact for the school district. And I don't think that means that anyone is going into this with their eyes shut or any of the other analogies used tonight. I respect everyone on this board immensely. I think they're some of the most informed, educated people that I've ever had the pleasure of watching and interacting with. And I would think everyone in this room is coming to it with different viewpoints. But I don't think it's fair to present this that is the developer is coming out of this somehow ahead. That is a loss for the school district. There is a way for multiple constituents to win in this, and I don't think this idea that Hampshire should just be gifting you the land or not asking for a deal at all. I think that's a straw man argument. I think that's a false choice, and I think it is in the school board's realm to be evaluating what are the pros and cons of this. And yes, it might benefit the developer, but it also might benefit the school and the parents and the children in this community. And I appreciate the very difficult decision you're in to listen to all the different community members. But as the school board, I implore you to not just look at the concerns of a few, but really I empathize with you that you're trying to evaluate this from so many perspectives. But at the end of the day, I appreciate that you're doing this for the students and the school community. Thank you.
Good evening, Jane Herzog. I also live on Cove Road. I have 2.
I'm sorry.
Thank you for meeting with us. I'm a resident of Orienta. I've lived there 34 years. My name is Jeff Stillman. Sorry. I'm a business owner in Westchester. I'm a developer. I also own a property management company. So I know all about condominiums and what's involved with them in townhouses and development. I also was a member of Hampshire Country Club. My uncle was one of the founding members of it, so I know the club very well. Not there anymore. I was there for over 25 years with my family. So, a couple points. Hampshire golf course in the land is basically a bog and a flood zone, and there's no way. I know I've met with the greens people there, and I've dealt with them, and I know nobody's ever been able to properly control the flooding issues of the golf course. So and any land that's going to be built there, any development on the land is never going to be controllable. The other issue is when the developer builds the condos, townhouses, the homes, at some point you're going to have a community association that's going to have to maintain the property and all the valves and all the flooding walls and everything that's apparently going to have to be built to control the water. And that obligation to be put on a board of directors in the community there, and I've had experience with it, can be very challenging. And financially, it could be very difficult for them to maintain. And I'm just telling you this so you understand what could happen down the road when these developments get built. Also, I don't know if you're aware, I forgot when it was, in one of the hurricanes, a resident died trying to drive through the golf course from the flooding. So you do understand the major impact of the flood zone there. I also know there are valves all throughout Hampshire, especially one that's on the Homick side, that I used to go with the greenskeeper there and watch it turn it on and turn it off when the floods were coming. And again, you're going to be at the mercy. If you have this land for fields, where you're going to be at the mercy of another partner to help kind of control those flooding issues. Like I say, down the road, the money isn't there, the proper management isn't there, things happen. You're going to have something that's going to not have any value. I mean, I'm not in favor of the development. The only thing I was in favor of is if something was built possibly around the Hampshire Country Club, but half the size, because it's too big. And what I think, and I've known it from a developer, rather than give you land, if you need the school to be prepared down the road, have them give you money. And that money could be put away and ultimately for building. And that's a better way to do it rather than try to get the land, especially this land that's pretty tainted. Anyway, I just wanted to know from a practical matter from me dealing with these issues. Thank you.
Good evening. Jane Herzog. I also live on Cove Road. I have 2 kids who went through the school district and a granddaughter who is currently in Central. And Jeff Stillman just spoke to you about the flooding. I think that is something that probably most people in this room are very aware of because it's visible. Most people have seen the golf course look like the Colorado River, and on many occasions, because it is indeed a basin. And you cannot keep Long Island Sound out. It is impossible. Whatever gates they have will never keep Long Island Sound out of the golf course. It's incredibly dangerous, and as Jeff said, one of our neighbors perished on the golf course during one of these events. But what I'd like to address really is the other environmental issue that people have referred to, which is the toxicity on the golf course. Some of you may or may not be aware that there has been unrestricted use of pesticides since the 1920s, when the golf course was first built. There are many, many golf courses around the country that where developers have hoped to build houses, to build condos, to build townhouses, to build all kinds of residences, where the community stopped them because analysis of the soil proved to be so toxic and so dangerous that they absolutely could not approve it and they did not build. It's somewhat ironic that while we are hoping to do something to improve the lives of the students in our district, that the board would consider building on land that indeed has shown to be filled not only with arsenic but with other contaminated metals because of the unrestricted use of the pesticides. The fields, when left untouched, are generally okay, but once the fields are disturbed, once the ground is disturbed, there is tremendous danger in inhalation, in ingestion, or even touching the soil that is so severely contaminated with pesticides. So to try to improve our opportunities for the children using land that is so contaminated and the cost of rehabilitating would be so extraordinary, I think is something that you as a school board might want to consider. Thank you.
Hi, I'm Phil Palmer. So I'm in real estate as well, and I just want to say that there are many people who understand all the issues associated with this MOU proposal. They voiced their many factual points tonight, and go on and on and on. So you can, everyone's getting bored by now because we're almost saying the same thing. But this administration initiated the conversation with the developer. And it feels like without doing your full research, without doing your homework, and understanding the real impact of this contingent gift. I know it's been said. So all we're asking you tonight is to do the right thing. Don't sign the MOU. Finish your homework first and give us our valuable summer evenings back.
Hi, my name is Jason Chatterjee. I'm a resident of Merrimack. I have 3 kids in the school district. None of them are in the middle school yet, so this would be a gift that would accrue to their benefit. I really want to reiterate a similar message from the gentleman who just spoke. I think whether your legal counsel recognizes it or not, you represent a lot of political capital and the debate that you're about to weigh into. Clearly, by the amount of people who showed up at this meeting and have spoken, it will have influence on how people ultimately drive the outcome of a long case that people spend a lot of time researching and evaluating and sharing those opinions on. I'm hopeful that there's ultimately outcomes down the road that are the best for our community and for our school. I represent the job, realize you have a job to do to protect the students and all of your education that accrues to the benefit of our town. I guess I just have kind of one clarifying question, which is how much time did you spend as a group negotiating the MOU in its current form? What was the time period you had to review it? How many sets of comments did you send back? What were your key issues that you spent time making sure were represented in the MOU as well?
So I can say generally the administration worked with legal counsel to have conversations about what will be included in this draft, and I think it's important to reiterate this is a draft. It's not certainly intended to be a final document. One of the things that the board has to do, and what we started through the process at our last meeting, is have a public conversation about the elements of this. Certainly entertain questions from the board, and entertain questions that come from the community that participated in that meeting. I think the intention through this meeting tonight, similar to initial public conversation, was to look at this draft document, work with legal counsel to continue to refine it, consider it, and go through this iterative process. I mean, we do our business in the public, so it's important to point out that any conversation that we have, short of conversation with legal counsel specific to what's allowable under state law, we do business just as we do it this evening. So that's the level. So I would say that there's been work at the administrative level, or having conversations about what to consider. There's been discussions with, obviously, Hampshire in terms of the conditions. There's been work within the board to understand the legal limits of their responsibilities as a board in terms of considering this agreement, and that's where we are today.
Well, I understand. I'm glad to hear that you're going to continue to kind of work through the draft and go ahead and sign it. I think hopefully you realize the level of complexity and what you might be entering into, and also what little you're potentially getting in return for weighing into that political argument as far as guaranteed outcomes for the school. So what I would ask you to do is consider essentially valuing your position in this greater. And if you are going to move forward and sign a document that's going to bring this level of divisiveness into our community, you at least get a significant amount more back from the developer than what is currently being offered. Candidly, I don't really think the school is getting a whole lot for all of Gloucester that we're currently having. But could potentially get a lot more if
If you got it, yeah.
so, thank you.
No opinion either way. I simply said at the beginning that this is a process of considering potential gift and we're no farther along. I think it changes.
Hi, my name is Aaron Niedermeyer. I live on Cove Road, disclosure, which apparently means that that's a problem. But I'm actually in commercial real estate finance, so I'm coming at this from a slightly different angle than maybe some others here. And a lot's been discussed about positions on the politics, and I'm not going to do that. But I read the document, and the document states that the district has determined that it's in the best interest for the developer to get the final approval so they can use the land. Right? I have two questions. Number one, can you provide the diligence you've done? My job is transactional based. I arrange capital for developers, for real estate investors and owners, and in every deal we do, there's a diligence period. So my first question is, to sign a document that says that you've already determined it's in the best interest, I imagine you've done quite a bit of due diligence. So I would think that you could share that with the folks in this room, because I think if someone stated to spoil the plan, it would be crazy to not look at this, and I agree with that. But I think it's important for everyone here to understand the diligence that you've done. So can you explain to everybody the impacts on environmental environment? Have you looked at other sites that could, if this is a spot zoning that has changed from marine recreation, have you identified other marine recreation or similar type sites that other developers or owners could say, well, you gave the developer here that zoning, so now I want that zoning, and the impact that might add to the school system. Have you done a study that shows the cost of remediating the environmental issues? So it's not just gifting land, because I do a lot of deals where the land is worthless, because the cost to actually build it is monumental. So someone says, I don't want it. So have you done that research yet, or is that something that will occur in the future? Because I think it's a bit, we're jumping the gun a little bit if you're going to sign a document, right? That's what you were voting on. Forget all the other things in here. You're voting on a document that says determine it's in the best interest. If that is in the best interest, okay. I think my concern is I haven't seen any diligence, and the time frame, correct me if I'm wrong, but the vote is on the 20th. The time frame has been going on for 10 years or more. I don't know, I'm new to the area. From the point where this was announced to the vote was like 3 weeks. So it's confusing to me, not having seen any diligence, why this is happening so quickly and already determining it's in the best interest. If you have all that diligence, awesome. If you could share it, I think everyone here on both sides would probably want to see that. And if you haven't done that, I think that it is very important to explore this. But take your time, do it the right way, right? I have clients who are doing real estate deals, they don't just sign something unless they really know what they're getting into. And so maybe we could slow it down a little bit, figure out the things that, some of the things I just touched on. I'm sure that there's a lot of other very smart people, both on the board and your advisors, who could say, hey, let's look at this, this, this. And so we know it is definitively in the best interest of the district. And if that's the case, vote on it and pass it. That's all. Thanks.
I just want to add one thing to what the gentleman just said. In my mind, on the due diligence, because it is very important for you to do that. Someone else brought up earlier about the cost of paying an attorney. You guys are using all this stuff, and whether it's the best use of our money right now. But if you are going to do the due diligence, which I think you should do, I don't know how to the extent you've done it, you should have that developer pay for that as well. I don't think that should come out of our pocket. So I just wanted to add that on. It just occurred to me as the gentleman spoke. Thank you.
I'm John Cecil, long-term resident. A little bit near, I'm actually near the comic school, but not particularly affected by the development of the condominium, if that happens, so you know all that. I think nobody here disagrees with the fact that we need more things for the schools, right? That's clear. We need more buildings, we need more playing space, playing fields. That's obvious. The issue and what you're hearing tonight is the problem is the MOU and the terms of the MOU. First of all, and I guess the attorney to the board wasn't here when this was made, it seems like the agreement is illegal on its face under New York lobbying laws. If that's true, it's a non-starter. And you should for sure make sure before you sign an agreement that you are absolutely confident in your legal ability to sign an agreement which causes you to actively support a real estate development in exchange for value more than $5,000, which I think is specifically ruled out by legislation in New York City. Secondly, the idea that this is simply providing information from the developer is not correct. If you really look at the terms of the MOU, it's specifically requiring you to distribute information for them to the school community. That's lobbying. That's what that is. It also prohibits you from meeting separately from them with any government official or regulatory body. It's probably illegal for you to agree to do that, but as a school, you certainly shouldn't do that. Your interests are not the same as theirs. There are going to be times when you're going to want to meet and have discussions with regulatory bodies and other parts of the community without their being there, but that's not what this agreement allows. The problem with the MOU is, the way I think about it, is that it is in fact delivering nothing to you. If you look at, by the time you add up all the terms and conditions, time frames and all that stuff, the school's getting nothing. At the same time, the school is giving up a lot. It's giving up its independence. It's aligning itself with a real estate developer that is trying to force the village to do something which is bad for the village and which the village has already rejected. You can see already from all this here that this is an extremely divisive issue. You're wandering into an extremely divisive issue. I don't think it's in the interest of the school to do that. So the challenge that you have to me is to think about how can you actually accomplish your goals without this MOU, because the MOU is the thing that's the problem. Pursuing land, pursuing opportunities are obviously things that you should do. But aligning yourself with a real estate developer, you will be seen absolutely by the community as being in bed with the real estate developer is bad for the school. You know, you talked about you have to do things that are right for the school. I get that. I think it's actually overstated because I think you have an obligation to the broader community, not just the school. But this is clearly not in the interest of the school to align itself so clearly and so publicly with the real estate developer. And that's exactly how you'll be perceived. They're already launching a PR campaign based on the planned adoption of the MOU to say that the school is supportive of the rezoning. That's what's going on in the community right now. So you're going to be seen as supporting this rezoning proposal, which is not in the interest of the village, which is heavily opposed by members of the community. And as a result of that, you're damaging your reputation. So you should know that.
Hi, my name is Katie Shine. I have 3 children in the district. I live in Larchmont. I'm not on Cove Road, but I surprise, I'm here to implore the board to consider this gift. I understand how divisive this is. I understand how upset everybody is. I myself sit in meetings in the elementary school, in the middle school, in the high school. I have kids that are athletes, I have kids that are not athletes. But I sit in meetings where there are constant conversations about the lack of space, the lack of parking. My middle schooler refers to going to middle school as jail. I understand that's being worked on, but we deserve to explore better opportunities for our children. And correct me if I'm wrong, I actually am not, I don't understand because there's been so many of the same conversations. But I do believe that this can happen no matter what. So if this can happen no matter what, and if this developer is going to get money, good for them. I don't care. I want there to be an opportunity to explore the space, to explore the fields, to explore multiple schools for our children, and to have that conversation, and to hopefully find a middle ground. And that is what I think that we should do, but if we turn this away, I would just implore the board to explore this opportunity, to take the steps, and to move forward with what is next here.
Hi, I'm Karen Geringer. I lived in the village of Mamaroneck since I was 3. I went through the school system. My kids went through the school system. And I have complete utmost respect for anyone on the board. Hardest job I can think of. I'm only inspired to it. So when this offer came your way, of course you have to consider it because of all the value it could bring, all the things that the kids need. However, probably you didn't know, or perhaps you didn't know all this background about what's gone through for zoning, numerous times the lawsuits. Like I could imagine that perhaps you didn't. And so what I really want to ask, and I know that people in this room may know this answer, but I'm sure that some don't, is if the MOU is to convey information, you can convey information otherwise. I'm not sure I don't understand what the value of the MOU is, because it seems like once that line is drawn, we get into a really tricky, potentially divisive, it will be divisive, no matter what, even if it's the right thing. So why do we need that thing? Why are you pursuing that just in order to consider the gift or to consider the land in some way? I don't really understand it. I figure other people might not also.
Thank you. So I will say, yeah, there is certainly, I think, an element of this. I think everyone here on the board appreciates that that Hampshire, in soliciting this agreement from the board, wants to use that in their negotiations, deliberations, applications with the village. I don't think that that's lost on anybody. That doesn't mean that the village has to agree. It doesn't mean that the board is negligent in its advocacy or in its duties as board members. I think some of the questions that have been raised here. Well, if they just if they want to give the land, then just give the land. What Hampshire is saying to us is we can't just give you the land because if we need to go ahead with the single-family homes proposal, we need that land. And we won't be able to go ahead with our single-family homes proposal if we, excuse me, I appreciate that. And again, that's not the school district's issue. Whether they can go ahead with the single-family homes proposal or not is not for these people sitting up here to decide. That is for the village, it is for the planning board, it is for all of the other people whose job it is to make that decision. The district, the representatives here, the administration, they have an obligation to provide factual information. It would be my expectation that the village would want to hear that information.
But can't that be shared anyway? Like here you are, you're giving us information. The agreement seems to me like a very sticky point because it does seem to then say, we're saying it, we're not going to take it. It sounds, it reads to the community, like we're going to say it, and like the village then it's up to the village to decide, which theoretically might be true, but we know that things are more complicated than that. So I'm just not sure why it has to be that. And is it phrased as an agreement, but what is the board agreeing to? Agreeing that you'd like to get the land? I'm just not sure why.
Yes,
I'm just confused
absolutely. So the district, in the absence of an agreement, the district doesn't get the land. If Hampshire doesn't agree, doesn't sign a document saying if this goes forward, you'll get land. And that may be. It may be that this deal never materializes, that the village never approves it, and the land is not given to the school district. That may be. No one is disputing that. The issue is, does the rezoning, does that initial application benefit the school district?
It's not just the issue there. I mean,
and I think,
oversimplify
well,
it. That's a huge issue for your primary issue, but I would think that it all comes into conversations, and I just don't understand why it seems like it's becoming more confrontational than just based on this here, or controversial, I should say, anyway. And I'm just wondering if there's not a way, easier way. If you're saying just to convey information, well, we can convey information in many ways, right? And does it happen by next week? We try to, like, is there more work to be done before money is spent all around also on resources?
and that's certainly a possibility. And look, I welcome the opportunity to sit down with Mr. Murphy and legal counsel and have those discussions. Again,
I do understand it's your first thing to think of it. Just after that.
I'd be happy to facilitate that.
Absolutely.
So I just want to, just from a time perspective, we're going to continue for about 10 more minutes. So there's individuals that had get the chance to speak. There's some people who had an opportunity to speak multiple times. So I just want to say we agreed to a 2-hour public conversation. I think, certainly we want to make sure that people have an opportunity to share their opinions or ask questions. So I just want to say, has anybody not felt they had the chance to speak? Then we'll just say 10 more minutes to complete this discussion.
Councilor, so question, please. Can you explain how the town property is not in any of the plans, but that you believe that they can't build their housing without the town property?
That is not something that I looked into. That is something that the district's architects and engineers looked into. They drafted the sketches. I was not involved in those conversations.
No, when I asked you,
yeah.
Okay, if you look at the plans, there's nothing in the plans that affects the town, correct?
I don't think that's accurate. I actually think it does. I think the Hammocks Road, the relocation of Hammocks Road.
Okay, but there's nothing that the town has to do.
I'm not sure if I agree with that.
Yeah. The town is not a party to the agreement. If that's what you're suggesting, the town is not a party to this agreement. That is correct. But yes, certainly it involves the town.
Okay, so let me get to the end because it's real simple. So wouldn't this really call, along with talking to Tom, for you to talk to the people at the town who actually have the authority here, that can do what you want them to do?
I think the answer is yes, and I think James here, we have a conversation. It's about the need to have a conversation. So that's where we're
I love conversations about conversations. Thank you.
Can I just ask you 2 questions? What's the impetus to do this now? It's the end of the year, everyone's jammed, this development's not happening for a really long time. We don't understand it, that's what's clear. It's really clear that there's not consensus. Let me make a suggestion. There are people in here who are willing to contribute time and effort to resolving this, and there are people with expertise. And we all want the best result. Why don't we create a committee, study it over the summer, and come back in the fall, and then reconsider it in a really much more organized and coherent way, with land use council explaining the situation, litigation attorneys explaining what's actually happening, what the condo association or the developer can or can't do with condos, with single family zoning. We don't know. So right now we're signing on as a school district to agree to do something to aid a situation that we don't understand, which potentially puts us in a very precarious position if we are A, acting as lobbyists as a school district, and B, if we end up putting ourselves in a situation where we are contributing to flooding or environmental contamination. None of that is a good result. We are absolutely not ready to sign this MOU at this point, and my strong suggestion is that you say to the developer, let's wait, we'll reconvene in the fall, we'll set up a committee, people will come in and contribute their time, we'll have spent a little bit of money on legal, and we'll come to a resolution that makes sense. Why now? Because it's his timeline, because he offered it. Guess what, he's still gonna be in there in the fall, and he's still gonna offer it then. He's hoping to pull a fast one, that's what developers do.
First thing I want to say is that I really appreciate this discussion and the fact that you are open here and listening to all of this. Frankly, I think one thing that has felt very wrong about this, and I understand the background that you provided, Doctor, about all the discussions and so on, but it's all been below the radar screen. Nothing's been made public. So all of a sudden, this thing that has huge consequences potentially for the community is sprung out there in full form with a fully negotiated MOU. It doesn't feel right. It doesn't feel like the process that the school board should be going through to have a full public discussion of this and all the issues. So whatever you end up deciding, you at least get the benefit of all this input. So the first thing I'd say is thank you for doing this tonight. I think it's been terrific. The second thing I'd say is kind of echo what was just said, which is that I think the right path, the better path forward, to my mind, given all the issues that have been raised, which aren't going to get resolved in your minds between now and the 20th, is to not approve the MOU as it's currently written, but to step back and think about the full set of issues involved here, including examining in much greater detail, which you actually can do without the involvement of Hampshire, the feasibility of some of the things that you want to have to, because as someone will say, a lot of that information actually exists in the public domain. So it can be investigated. And so if you decide to proceed, you're eventually actually proceeding with something that you have more confidence in could actually work. One of the big problems with this is it seems actually for a whole variety of reasons that this is not likely to ever materialize as a gift to you. It's not likely for all kinds of reasons. Embedded in the agreement, all the conditions in the agreement, together with a lot of the difficulties, practical difficulties of developing the land, and the expense of that, when you add all that up, you say, gee, that doesn't seem like it's gonna be likely to happen. And at the same time, by signing the MOU, as I said earlier, you're making yourself an agent of this real estate developer. You're tarnishing your reputation by seeming to be in bed with them, doing something which a big part of this community really doesn't want, which is what you've heard tonight. So I think personally, try to speak calm, the better issue is to say, let's take a pause. Let's not sign this MOU as negotiated. It may have serious legal issues. It has a bunch of practical and political issues for you all. Let's step back a little bit, go through the investigation of whether this is actually going to be economically feasible to do, continue to get input from the community, pros and cons, right? And eventually, through a more public process, come to a decision which will hopefully then have the broad understanding and support of the community, which right now it clearly doesn't have. That's it. Thanks.
We have time for one more. Okay.
Hi, I'm Chris Rosa. I'm a 17-year resident of the community. I have 3 kids in the district. I have 2 currently in Homix. Thank you so much for doing this tonight. I know there's a lot of people here from the neighborhood where there would be the development, and I totally understand that concern. But there is a much larger community that we have to consider, like all of our students that live all around the district. And there may not be a lot of them here tonight because they have different motivations than the residents of Cove Road and Homix Road, but there are a ton of people, as you can see by committees being formed, Fields for Kids and whatever, that are very concerned about space issues and lack of fields. And this sounds like a very complicated issue, so I definitely think, there's many sides to be considered. If the land is not buildable upon, then that will be decided by the town or the environmental committees and other people than the board. So I just hope that we do seriously consider this proposal of land. Obviously, it's not going to be a clean gift. There's going to be an expected reciprocity of some kind, and that's okay as long as we understand what that is and we're willing to do that. But I just think this is potentially a once-in-a-lifetime opportunity. This one of the only green spaces still available in our district is sitting right next to our school, and is a potential 10 acres. I don't see that opportunity coming up again. The other thing that I'm concerned about is if in my understanding, that area is already zoned for single-family homes. Is that correct? Okay, but but currently it's zoned for potential building. So there is the potential for something to be built there. And if it's not, at least here we have like a potential seat at the table and maybe we actually get something out of it. The worst case scenario in my mind is that something else is built there and now we didn't get anything out of it and now it's gone. It's gone for good. So I know there's a lot of angles to consider and I think that's important to do so, but I hope that we're also considering this opportunity for what it is. Thank you.
Well, can I just say one last thing? The only thing I want to say was, we are not far apart. Whoever just spoke, I had kids that went through the district. You might have missed it, but I was on the school board when we went through, and I understand the desperate need for fields and the desperate need for additional space. We all want that for the community. This is not about that. This is about the MOU and the fact that, and I hate to say this, but this is an ephemeral, ostensible gift that by virtue of the terms of the MOU will never materialize. I wish it would. I wish we could get that land and I could, when my grandkids come over, walk over from my house to those fields. And you should know, I would not care if the condos are built. I live way, way, way away. I am a person who would be massively impacted by these single-family homes. In fact, for certain reasons that I won't mention, the entrance to the single-family development was placed in front of my front door. All of the tens of thousands of truckloads of fill would have gone onto the property in front of my front door. So I, more than anyone in this community, if it really were a choice between the 105 homes and the condos, I would say to you in an instant, the condos are right. But that is not the choice. That is the false choice that this community is being fooled into thinking by developers who want the condos. That housing development will never be built. It's been rejected. It's technologically impossible. It is subject to flooding. There are illegal reasons for it. And that case has not been supported in the courts, and it will not be. So I just want you to understand, we are all as a community on the same page. We all want the same thing. It's really an issue of how this MOU has come about and what its terms are. The fact that it terminates in a year and only will, you'll never get final approvals in a year. It will take 10 years. There is never going to be a gift. So that's the problem. The school district is being used to basically create public opinion. If we could get an agreement that said, we will give you the property and you can look at it and see if it's good. No strings attached, nothing. Great, let's do that. Let's take the property. It would be great to have a field there. It would be great to build the additional buildings at Hampshire. So I just want people to understand we are all on the same page.